between watching and playing violent video games and excessive aggressiveness and violence. Now, respondents
Counsel, you conceded in the litigation below that the harmful conduct to others is not a sufficient basis for upholding the law because the state has other means of preventing violence to other people, right? And enforce criminal laws. So instead, you need to focus on the psychological harm to the minor. I'm not seeing that from the fact that they act out, right? Are they unhappy when they're acting out? So are they frightened, depressed? What is the psychological harm to the child?
Respectfully, Your Honor, the fact that they are more aggressive, more violent, is psychological harm to the child. That is harmful to the child, and I would note, respondents come back and say, well, there are data showing correlation, but there is nothing proving causation. And indeed, that's what the Ninth Circuit said, is that the data don't prove causation. It's interesting, because almost the verbatim argument was raised and rejected by this court in Ginsburg. Ginsburg said, but the growing consensus of commentators is that while these studies all agree a causal link has not been demonstrated, a causal link between looking at so-called girly magazines in Ginsburg and harm to the child, they are equally agreed that a causal link has not been disproved either. And in Ginsburg, they said that's enough.
But counsel, that was enough under the rational basis test. The rational basis test has never required proof of causation. This court has always deferred to legislative judgments if they were rational, and that was clearly rational. Now, do you not have to prove some causal link between this, between these games and these kinds of harms to children in order to survive even the intermediate scrutiny that previously suggested was good?
If I could follow up on Justice Cooper's question, there's a lot of water under the dam between Ginsburg and now. For instance, the Daubert decision, which tells courts to be very wary of junk science and to test evidence by some scientific standard. And so how are we to judge these kind of random observations of the harmfulness of the video games?
And to follow up on that question, was this evidence in any way excluded or even objected to in the Daubert challenge?
Let me try to answer those questions. And I would respond in two ways. Number one, what the Ninth Circuit did is it engaged in a battle of experts. And it got into, well, this expert argues this, but the other side's experts argue this. It began weighing the public policy evidence on one side or the other. I would suggest that's precisely what legislatures are for. That is not a task that courts are particularly suited to do, to analyze the social science data behind the disputing side. Is it true that both sides had their experts? Yes. Which is exactly why this is well suited for legislatures to look at. Secondly, I would make a point. There are some propositions for which data and evidence are not required. The proposition that having 10-year-old children pretend to beat a child to death, light her on fire, and urinate on her is harmful to children.
This 10-year-old would get the video game how? They cost $50 or $60, and I think you can see the parent is entitled to if the parent wishes to buy the video game for the child. So the 10-year-olds are streaming into the stores with $60 a piece to buy these video games?
In the modern time, there are certainly 10 and 12 and 13-year-olds that have sufficient money to buy these games. And there is no dispute. It is certainly true that parents can choose to have their children play these games, but the proposition that the vast majority of parents would not wish for their children, if they knew this, if they knew they were acting out this gratuitous violence.
So, counsel, why do you even permit parents to give it to children? Why don't you just ban it and consider it child neglect?
Among other things, I don't think the state could do that constitutionally, because the predicate of Ginsburg and the predicate here is that parents are the ones best suited with rearing their children, with making the decisions what materials are suitable or not. This court focused in Ginsburg that the magazines that were criminal to sell to children there, a parent could buy and give to his or her child. And so when you shift into parents giving the material to the children, you get out of this court's case law that focuses on kids, and you get into this court's case law that focuses on adults. We don't dispute that if this law prohibited these video games for adults, it would raise very grave constitutional issues.
Mr. Cruz, I'd like to come back to my question. How does your social science establish a causal link if we conclude that the intermediate level of scrutiny applies to your case? And assume for a moment that the notion that some propositions don't require evidence is not going to win the day for you in a First Amendment case.
Mr. Cruz, let me just say, your time is up, but please answer the question.
The data do not conclusively demonstrate causation, they demonstrate only correlation. That was precisely the same as the data in his case.
Thank you.
Mr. McConnell?
Madam Chief Justice, and may it please the court. I came prepared to argue the case that was presented in the briefs to this court, and I find myself confronting a rather different proposition. In the lower courts, the state of California argued that this court should extend the principle of Ginsburg to violent video games and thus apply rational basis scrutiny. Now I hear that the state is contending for intermediate scrutiny, citing instead of Ginsburg, or in addition to Ginsburg, the case of the United States against O'Brien. I quickly checked the petitioner's brief. I didn't get past the table of cases because United States versus O'Brien is not even cited in petitioner's brief.
Mr. McConnell, that's a very fair point. The question that I put to Mr. Cruz was not prompted by the briefing of the case, and I understand your dilemma, having been in it myself a few times. But I would like for you to even impromptu here, address the consideration and the concern that I have voiced, that this isn't like a magazine, a girly magazine, or a movie, or anything else in this court's cases, but rather in light of the interactive nature of this product, in which actual active conduct by the player is involved, in which the player is actually in a simulated way, but is performing the acts of violence that Mr. Cruz has described here. Does that not distinguish this in a constitutionally significant way from Ginsburg and the other cases?
Well, Justice Cooper, the idea that interactivity takes speech into a different, a less protected or unprotected category is, of course, completely unknown to this case's this court's jurisprudence. Were it true, there are a number of interactive speech activities that would fall within that, including Justice Craven's excellent hypothetical about performance in a play. There's very little that would be more interactive than that. Debate is interactive.
Would it be beyond the legislature's authority to regulate a play in which a 10-year-old child did not act out Romeo and Juliet, but acted out actively the acts that have been described by Mr. Cruz?
I think you would have exactly the same case you have here. You would have content-based restrictions upon speech.
And conduct.
And if it is so harmful, of course, it isn't absolutely protected. If it is so harmful, let the state come in with its evidence and show that it meets the appropriate standard of scrutiny, which I believe is strict scrutiny. I also believe that this would clearly fail under intermediate scrutiny. I think it fails under anything other than the most passing application of rational basis scrutiny.
And why should we extend Ginsburg? Why is it that communication about violence is worthy of greater protection than communication about sex?
Well, the question isn't really what is more worthy. Ginsburg did not, as interpreted by this court in subsequent cases, Ginsburg did not rest upon a cost-benefit analysis about obscenity. It rested upon what the court has called a traditional, long-standing prescription. That is part of the historic understanding of what the freedom of speech is in the Anglo-American legal system. There are certain categories that have always been understood to fall outside of that. There is defamation, there's obscenity, there's fraud, there's incitement, there's speech that's incident to criminal activity. This court just last year declined the invitation to expand that set of categories to new, novel types of activity. I say that for just the same reasons the court was reluctant to extend those categories in Stevens, it ought to be reluctant to extend the category here. But there's a more particular reason why Ginsburg is not such a great analogy for the state. First of all, remember that Ginsburg applies to all media, not just to interactive video media. It applies to comic books, it applies to television, it applies to movies, it applies to books, it applies to everything. If this court wants to embrace Ginsburg for violence, it is going to be embracing a proposition which liberates the governments of this country to regulate violent exposure to violent materials in all media, not just this one. You cannot cabin Ginsburg. Secondly,
Counsel, if the governing criteria isn't just violence, but it is the age of the individual, does not the parade of horribles that you suggest stop at the age of majority?
it stops at minors, but it does not stop at this particular medium. So it includes censorship of minors' access to any of these mediums.
Counsel, this court in recent years has drawn a line quite rightly between minors and the rest of the population. We excluded minors from the death penalty and in some instances from life without parole because they have not reached the level of mental and emotional development to be fully responsible for such acts. We found it constitutional to suppress minors' speech about drugs because the state's interest in preventing advocacy of drug use exceeded their First Amendment rights there. Why is this right to have such violent and obnoxious video games more important than the right to make a commentary about drug prohibition? I don't understand.
Well, Justice Raven, the Frederick against Morris was specifically in the context of a school activity, and Justice Alito's concurring opinion, which is controlling, makes it clear that had the government attempted to apply that ruling outside the context of school activities, it would have been plainly unconstitutional. Thus, that case supports our position.
But it also explained that the government's interest in fighting drug abuse was so strong that it justified suppressing the minors' First Amendment rights.
Within the context of school activities, where the government controls the pedagogy, the government is the teacher, and within that context, the government has considerably more latitude to regulate what's being said than it does out in the free world.
Mr. McConnell, what about the more general regulation of the broadcast airwaves? We care about children being exposed to even 7 dirty words, hardly obscenity.
Well, again, the rationale there is that over the broadcast airwaves, that it penetrates into the home uninvited. That is, you can turn on the TV, who knows what's going to be there, and thus it's not a matter of choice on the part of the families that receive the materials. These are purchased. These are put into the computer or the game player and deliberately watched.
The problem here is that these are purchased by the minor, by the 12-year-old, 13-year-old, whatever, and presumably without the parents' approval. That's the concern that I understand the state.
Well, Justice Cooper, we ought to limit ourselves, I think, to the facts in the record. And which show, according to FTC studies, that 83% of video games, of all video games, are purchased where the parent accompanies the minor. Although the state continues and persists in studying and in quoting outdated studies on this, the more recent FTC reports indicate that when they sent sort of mystery shoppers under the age of 17 into stores, that 80% of them were prevented from purchasing M-rated videos. That is a higher rate of compliance than we